So, let us start the discussion on the 1st February 2016 newspaper. So, in this context, the LGBT issue has come for discussion again. Now, if you remember my class, I gave you this particular statement. Democracy is not about majority dominating the minority. Democracy is about expansion of the public space and public debate to include multiple viewpoints and to what extent it can become diversified, and also debate has to be much critical and intellectual. So in this case, the rights of the people are the prerogative of the democracy. Our rights forms an important element of a progressive democratic society. So, any maturity of a democracy has to be evaluated based on to what extent it respects its minorities. It may be minorities by religion, language, or sexual orientation. So, to what extent the state is unprejudiced or not having any prejudice against the sexual minorities. So in this discussion comes the LGBTs. Indian civilization always allowed for the different types of the sexual orientations. If you see the Khajuraho temples, or if you see the Vatsayana's Kamasastra, everywhere different kinds of the sexual orientations are depicted and they are also being given due recognition. But after the Britishers have come into India, the colonial law, especially the Indian Penal Code, enacted in 1860 and section 377 has criminalized an unnatural sex against the order of the nature. The homosexual behavior is considered as unnatural and against to the order of the nature. Now, it has criminalized a behavior of the entire section of the community and only the sexual choice available to them. Over a period of time, the medical literature has evolved to consider that as a normal behavior, but however, the law did not evolve along with the medical literature. So, let us evaluate the legal trail of the LGBTs in India. In 2009, the Delhi High Court, it has given a landmark judgment declaring section 377 as against to the law or against to the constitution. So in this case, the High Court is very clear that it is deprivation of equality and other freedom rights to the sexually minority community. So, it has confined the section 377 only to the non-consensual penile and non-penile, non-vaginal intercourse, that is homosexual intercourse. Only if it is non-consensual, it is unnatural. It has also confined it to the sex with minors. So, to that extent, it has confined the definition under section 377. Now, 2013 Supreme Court judgment, it has reversed the earlier judgment, and then a curative petition is filed now and it is coming for hearing today. No, I think tomorrow. So in this context, let's analyze what are the reasons given by the Supreme Court while reversing the order of the judgment of the Delhi High Court. So what the Supreme Court said is, it is criminalizing only certain acts, not the sexual behavior of an individual. Now the question is, how can we separate a person from an act? And this is only the sexual behavior that is available to the homosexuals, that is LGBTs. Then how can we provide them with this, deprive them with this chance of sexuality? So this is the first question. The second thing is, medically it is proven that the homosexual behavior is not against to the order of the nature and it is not a pathology. The DSM-4 of American Psychiatric Association, Diagnostic and Statistical Manual 4, and International Classification of Diseases of WHO, they no more recognize homosexuality as a punishable crime. And next is Ireland, United States of America, they recognize inheritance rights to the partners of the homosexuals. The world is moving more towards a liberal society, but India's this judgment of the Supreme Court is considered as retrograde. Another statement made by the Supreme Court is, in 150 years of history, only 200 cases came for prosecution. If you see the fundamental rights, even one individual or one case, the Supreme Court has a responsibility to take it forward. The fundamental rights are guaranteed, the freedoms are guaranteed at the level of the individual, and no numerical value is required to take up this. And finally, in a democracy where the rights of the minorities are deprived, the democracy and the state becomes an instrument to oppress these minorities, oppress their choices. Now, if you see the section 377 is mostly misused to extort the homosexuals, that is LGBTs. So in this context, we have to say that the Supreme Court has to take a proper view of the situation over here. The next is Indo-French relationship. So it is an historical enumeration of the relationship and consolidation of all the points which we have discussed in the previous lectures. Rakesh Sood is the previous diplomat. So India and French, they have a very long-term sustained relationships. 5 France presidents have visited India and they are the guests at the Republic Day celebrations. So in this context, after India's nuclear tests, France is the first major power that has involved with dialogue. And the second thing is, France is the first country India came with a strategic agreement. After that, the strategic agreement and its scope is extended to include many other areas. Now, cyber security, terrorism, defense, space cooperation, everything are the part of this strategic cooperation with each other. Now, added to that in the next level, today we are talking about a standalone agreement on the terrorism because France is also a victim of terrorism as like India. But one area where we still have to make the things progress, that is trade relations and people-to-people exchanges. So there is no direct connectivity. There is a direct connectivity, but it is much less frequent compared to United States, Germany. So we have to strengthen this direct connectivity and people-to-people exchanges, cultural links between India and France. So in this context, the major problems with regard to the trade or lack of free trade agreement, as quick as possible we have to close down this India-European Union free trade agreement. Now coming to the next editorial, that is Gujarat Anti-Terror Bill. So it can be described as Gujarat Control of Terrorism and Organized Crime Bill. So this is made in line with the MCOCA, Maharashtra Control of Organized Crime Bill. So now, what are the provisions of this bill? If any phone tapping has to be undertaken, the state home secretary has to take the permission of the union home secretary, then only he can authorize. Now, without that delegation, under this bill, state home secretary can authorize for the interception of the calls. And these interceptions of the calls can be admitted as an evidence in a court of law. And as of now, 90 days is the time allowed for the filing of a case. Now, it is increased to 180 days to file a charge sheet under the anti-terror law of Gujarat. And the most draconian provision is any evidence admitted before superintendent of police to the rank of SP officer, it shall be considered as an evidence in a court of law. If you talk about the self-incriminating evidence, it is prohibited under the Constitution of India. But however, an evidence given before the executive, it shall be admitted as an evidence according to this law. These are certain draconian provisions. If you see India's experience with the anti-terror laws, it is not a pleasant journey. Either it is POTA, it is TADA, or it is Armed Forces Special Powers Act. Everywhere there is an abuse of the human rights. So in this context, what we need to do is, with the existing provisions, how to improve the capabilities of the investigative agencies so that the speed of investigation can be increased. So in this, the work area has to be to improve the criminal justice system rather than improving the strength of the laws. The next article is related to the push for IMF reform. You know that the IMF, an international economic institution, is not reflecting the so-called as global economic order which is existing as of now. In reflection of this, IMF reforms were suggested. The major reforms are the quotas have increased for the BRICS nations. So most of the BRIC nations, other than South Africa, they become the part of top 10 contributors of the IMF. Now India and China, their role have specifically increased in IMF now. If the quotas are increased, it means we get greater voting rights with regard to the governance decisions of IMF. And the second is, we also have to contribute higher amount to the IMF. So in this context, the total value has increased to SDR 744 billion. ISDR is the IMF currency. So that is a progressive step. And executive directors who are previously nominated are no more allowed, and all the executive directors have to be elected now. So these are the few improvements. But however, the systemic exemption is still allowed. The systemic exemption, it allows the width of the developed countries to continue over the IMF. So more than the economic conditions, political considerations are directing the IMF and its administration is the major complaint. And this exemption rule provides a chance for this further. So in this context, the reform is just a starting point, it is not an end, and it has to move forward further. Coming to the India-Pakistan, now there is rehyphenation. During the Bush era, there was dehyphenation of India and Pakistan. It means that these two countries are considered in two different silos, independent from each other. So because of this, India's relations have grew with United States of America irrespective of its relations with Pakistan. On the other hand, United States was freely able to operate in Afghanistan irrespective of the considerations of India with regard to off-Pak issues. Now this flexibility is being lost. Now if you see Obama, when he came to power in the early years of 2008, he was recommending for the appointment of Holbrooke as a special representative for India, Pakistan and Afghanistan. Due to resentment from India, he was confined to in Pakistan and Afghanistan and to the Central Asia. Actually, Bill Clinton was proposed for that. Finally, Holbrooke came into the scene. So, but however, so this dehyphenation was very much in the India's interest and its deepening of relations with the United States of America. Now, this rehyphenation is not in the long-term interests of India. Now coming to the visa on arrival for the Japan and Korean investors. So we have already extended this to the Chinese investors. Now we are extending it to the Japan and Korea investors towards promoting Make in India and to attract the investors to the country. Finally, hold the fiscal reins are loosened. Yes, we can achieve both the things, that is fiscal consolidation and at the same time growth. So what this author argues is this. In India, the major challenge is not the proper planning, it is about poor implementation. So this fundamental problem has to be addressed through improving the capacities of the institutions, institutionalizing greater capacities, bringing in greater coordination at various levels of the government that can bring in huge savings for the economy, and both the fiscal consolidation and the resource utilization, proper resource allocation and utilization can go hand in hand. So that is what is the essence of this article. So thank you very much. For the IMF area, I have given yesterday 3 questions on IMF. Please practice them. We are expecting 1 question on IMF. Before week also I gave 2 questions on IMF. Please practice those objective type questions. We are expecting a question on IMF this year with regard to prelims is concerned. Thank you very much. All the best.